For judgment item number 1, WPC 5790 of 2024, WPC 5535 of 2024.
Considering the law laid down by the Supreme Court in the cases discussed above, we answer the questions referred to the full bench as under. While testing the correctness of a purely administrative order passed by an authority that is stayed within the meaning of Article 12 of the Constitution of India, which does not essentially require recording of any reason, and this includes an order in the nature of cancellation of a tender process /notice where a bid has not been accepted, the observations made by the Supreme Court in paragraph 8 of the decision in Mohinder Singh Gill versus Chief Election Officer do not have any application. 2. Before cancellation of a tender notice, there is no requirement of giving an opportunity of hearing or prior notice to the highest/lowest bidder, as such bidder does not acquire any vested right to have the tender confirmed in its favor on that basis alone. 3. When a tender process is cancelled prior to confirmation of a tender auction in favor of a bidder, the Supreme Court's decision in the case of Sudhir Kumar Singh is not applicable. 4th, in MS Bansal Infra Projects Private Limited, the division bench of this court has not applied the Supreme Court's decision in the case of Sudhir Kumar Singh correctly. Full stop. The High Court, 5. The High Court, while exercising power of judicial review under Article 226 of the Constitution of India, to direct the state or its instrumentalities to accept the bid of the lowest/highest bidder by interfering with the order of cancellation of tender solely on the ground of violation of principles of natural justice or on the ground of being bereft of reasons, cannot do so except in exceptional circumstances. The matter may be placed before the division bench for hearing.
I agree.
Item number 2.
Yes, Mr. I will file them. Filing. The petitioner is here. The petitioner is here in the control. Yes. Ask him to.
ଆପଣ ଯୋଉ ଅବଜେକ୍ସନ ପ୍ରିଲିମିନାରୀ ଅବଜେକ୍ସନ ଦେଇଥିଲେ ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ଦେଇଥିଲେ ନା ଆପଣ ନିଜେ ଡ୍ରାଫ୍ଟ କରିଥିଲେ ନା କଣ କଣ କହିଥିଲେ ଇନଷ୍ଟ୍ରକ୍ସନ କିଛି କହିନାହାନ୍ତି ସାଇନ୍ କଲା ବେଳକୁ ପଢିନାହାନ୍ତି ଆପଣ ଏଫିଡେଭିଟ୍ ପଢିଛନ୍ତି ଆପଣ କଣ ଲେଖିଥିଲେ ବର୍ତ୍ତମାନ ପଢି ସାରିଲେଣି କି ନାହିଁ ବର୍ତ୍ତମାନ ପଢିଛନ୍ତି ଦେଖନ୍ତୁ ଯୋଉ ଅବଜେକ୍ସନ ଦେଇଥିଲେ ପଢିଛନ୍ତି ଆପଣ ନିଜେ ଇନଷ୍ଟ୍ରକ୍ସନ ଦେଇଥିଲେ ନା ଆପଣଙ୍କର ଏଡଭୋକେଟ ଆପଣଙ୍କୁ ଆଡଭାଇଜ କରିଥିଲେ
आप हिंदी समझते हैं आप थोड़ा समझते हैं ये जो आपने एफिडेविट फाइल किया ये आपने उनको कहा था फाइल करने के लिए कि उन्होंने कहा कि ये फाइल कर दीजिए कुछ नहीं कहा आपने कुछ नहीं कहा आपने सिर्फ सिग्नेचर किया यही है ना लिखो
Okay, starts with
the appellant, the respondent in WA number 2491 of 2023, Sri Manoj Kumar Bal, who is opposite party number 1 in CONTR number 1/2025, is present in court. Full stop. In response to a query made by this court, he has informed us that
only file objections.
Preliminary objection.
that the objection, preliminary objection, which was filed on his behalf in the intra-court appeal, was on the advice of learned counsel for the on the advice of his counsel, Sri, what is your name? Sri Pradipta Kishore Bhuya. Stop. He has stated that he does not know the contents of the said objection Stop. Next. Today, a so-called reply has been filed, shown by Mr. Pradipta Kumar Bhuya, learned advocate, bracketed and enrollment number 10 of 1990, making following statement. Paragraph 1 to 5. 1 to 6. The said affidavit, said so-called reply has been shown by, it's not shown. What is it? Not affidavit.
So original maybe before you. Affidavit नहीं हुआ हुआ
No.
Last week.
Has been shown by Mr. Pradipta Kumar Bhuya,
So,
Pradipta Kishore Bhuya, ये डू यू नो आज एक एफिडेविट फाइल हुआ है, पता है आपको क्या है इसमें? आज कोई फाइल हुआ रिप्लाई?
ଆଜି ଆପଣଙ୍କର ଓକିଲ ଆମକୁ ଗୋଟେ ଦେଇଛନ୍ତି ସତ୍ୟ ପାଠ ସେ ବିଷୟରେ କିଛି ଜାଣିଛନ୍ତି?
भूल है जी भाई, वो तो ठीक है, बट वेदर यू नो कि इसमें क्या लिखा हुआ है?
ତା ଦେହରେ କଣ ଲେଖା ହେଇଛି ଆପଣ ଜାଣିଛନ୍ତି କି ପଢିଛନ୍ତି? ସେଇଟା ନାଇଁ ସେଇଟା ସତ୍ୟ ପାଠ ଆପଣଙ୍କର ଓକିଲ କରିଛନ୍ତି, କିନ୍ତୁ କଣ ତା ଦେହରେ ଲେଖିଛନ୍ତି ଆପଣ ଜାଣିଛନ୍ତି କି? ଜାଣିଛନ୍ତି ଯଦି କୁହନ୍ତୁ। He's saying that what he had written earlier, that is a mistake, that is what he is saying.
Asking to
समझ में आती है आपको? इंग्लिश पढ़ सकते हैं आप? अंग्रेजी पढ़ सकते हैं?
इंग्लिश पढ़ी पारंती?
Yes, Mr. Goya, see, now you have heard what he has stated. And we pity you. You are an officer of the court. Either you are so imbecile that you don't understand the serious consequences of what had been written in your objection, or you are so crooked that you can take any stand before the court. In any case, I don't know whether you have decided to leave the practice or not, but what you have done may have very serious consequences.
Beg pardon, my lord. Actually, he knows that thing. I have not adapted on my own. I have awared him, and he is a matrilineal constable. He has not so comprehensive power to understand the things. I have informed him. He is aware of this because he is scared. He is not telling the truth actually.
All
I
right,
have informed him.
all right, don't
I
worry.
have taken that. view
Mr.
and
Counsel,
we have
Mr.
discussed on the
Counsel,
thing.
see, Mr. Counsel,
I am not, my lord.
don't
Your
get
lordship's-
scared.
Your lordship's comment in the
Just-
closing days of our
just-
in this court is
just-
very much shocking. By
Just a minute. You should not be scared because
I am not.
please listen to us. You should not be scared because I will not be deciding your this thing, the contempt proceeding, nor the full bench matter. So you should not be scared. If you are scared of the Chief Justice, you should not be. I will not take up. Don't question the impartiality of the Chief Justice. Never.
I have not.
Yes, you have done it.
I have not. I have no such intention. I have not questioned about the impartiality, my lord.
And therefore, we are saying
About
this.
the Constitution.
All right, forget the let criminal be listed before appropriate division bench in accordance with the Odisha High Court rules under the orders of the Chief Justice. So stop. Yes, Mr. Acharya. It is too much.
I have read it.
It is too much. The Bar Council should be aware of it. What kind of how can such objections be filed? In my life, I have never seen this. I joined practice in 1990, and for the first time, as a lawyer and as a judge of Patna High Court or the Chief Justice of this court, I had not seen such language used in an application. What is this? I will not do anything. You don't be scared of the Chief Justice.
Actually, I beg
You
apology.
should. No, don't beg apology. Don't beg apology. You are incorrigible. This full bench list this matter on 2 weeks. That will do, mister. That will serve his purpose also. And that will serve everyone's purpose.
You have any objection for?
Indirectly, you succeed in its objection.
Yeah,
Indirectly, you succeed. Indirectly, you succeed in your objection.
my lord, I am now not inclined to appear in this case anymore because they are decided.
Do whatever you want. Do whatever you want. Your thing. Yes, ma'am.
I was on my legs in another court, unfortunately, I could not reach in time.
So when did you file your CMA
Same,
appeal?
the first IA was filed on the same day, and the lordship was pleased to dismiss it.
Restored.
DQ. The second matter is identical.
Item 2.
Yes.
And DQ.
Item number 3.
The other side, state and entity.
Sorry.
Mr. Aditya, the other opposite parties are there. State is there.
Then
Then NTPC Power Workers Union.
they're not, but I had served their counsel, but
No, notices were issued in that case,
yes, they had appeared.
in the main matter.
Yes,
Then let notices go.
as your lordship.
I think,
Both
We were under the impression initially that parties are appearing in this.
Look, I had served their counsel, but I think 1 and 2 are identical.
Yes,
And
issue
issue
notice.
DQ.
only 3 and
Issue notice 3 and
3 only. Mr.
Look,
Aditya,
notice will go to 3 only.
3 only. Others, Mr.
Yes, state
Das is okay.
And
Waves notice and extra adequate numbers of copies of scheme will be served on.
have you served?
yes, already served.
They haven't served.
I'm obliged.
Item number 3.
We have detail also, my lord. We have, my lord, when the matter was for the council withdrew its power by saying that brief has been transferred. Thereafter, my lord, my client was not aware of it. Same same month.
WPC number 23178 of 2022 was dismissed by which order?
4/8/2023. 4 August 2023.
By an order dated 4/8/2023, which reads as under. Stop the court control. In the present application filed for a restoration of the reproduction, it has been stated. What have you stated?
My lord, the council, Mr. S.K. Rathal, learned council that the brief has been transferred from them for which they have no instruction to in this matter, on the basis of which the honorable court was pleased to dismiss.
Considering the averments spent in the present application for restoration, the same is allowed. Let WPC number so and so be restored to its original sign. Yes,
I look at that.
Item number 4.
My lord, I am appearing for the appellant in this matter. My lord, this review petition is
No, but
based
it has
on
come for orders.
lordship.
It has come for orders for condonation of delay.
Yes, lordship. Yes, lordship. There is a delay of 10 days, lordship. If your lordship kindly condone the
He is appearing for the other side.
I'm
What is the delay?
10 days,
10 days. Delay of 10 days.
lordship, according to my application.
Limited companies. Limited company is one of the parties.
Who is appearing for the other side? Someone is appearing.
You are appearing for opposite part number 1, appellant. You are the appellant.
I am for the appellant.
Copies you restore? Don't have.
There is delay in. We have heard when counsel appearing on behalf of the parties. Stop. There is delay of 10 days in making the present review application. Stop. For the reasons 10 days given, for the reasons stated in the application in IA number 290, the delay in filing the review petition will control. Put up this matter for admission before appropriate bench.
I am deeply obliged, my lord. I am deeply obliged.
Item number 5.
The present restoration is filed.
Who is for the other side? They are restoring. Why was that your application dismissed?
My lord, the earlier conducting counsel had expired. The petitioner only.
What is the order? Someone was not appearing. This
My
was
lord.
for default. My lord, it dismissed for default. I'm sorry.
WPC number 1381 of 2022 to dismiss for default on the ground of non-representation. So, considering the averments made in the present application seeking restoration, the same is allowed in the interest process. Let WPC number 13818 of 2022 be restored to its original file. IA number 625 of 2024 stands proposed of. Yes.
Item number 6.
Well, also may kindly turn to page 46, fourth line for order, my lord.
Just a minute. There was a condonation of delay.
Delay is there, my lord. Here only correction of repetition.
How much delay?
State is the matter.
How much delay?
Delay more than 1 year.
All right. Where is the order?
Page 46, your worship.
46 of the review application.
Yes, madam. Fourth line.
46 of the review application.
Yes, madam.
That is the review.
Arithmetical correction.
Yes, madam.
It should have been
Yes, yes.
arithmetical correction, not
Yes,
review.
madam. Yes, yes, that I was thinking while. 1762 of 2022.
Instead
in place
of
of 263.
26370. Instead of
Yes, sir.
2370.
When this matter was heard by my lord, this was pointed out, therefore I have filed. Here the state appeal. It was the state appeal. They should have filed this application.
All right. Any party can file it.
No. That instead
Just
of.
Page 46
Yes.
is order dated 5/2/2023. 15/3/2023.
15/2/2023.
Yes. What is the typographical error?
Fourth line, WPC number 26370 of 2021. That should be 1762 of 2022.
Yeah.
No. File review of an order dated 15/2/2023 passed in WA number 1054 of 2022. Stop. The present review application is barred by limitation. There is delay of more than 1 year in filing the application. However, it appears that this review application has been filed for a rectification of a clerical error which has occurred in the order dated 15/2/2023, in as much as WPC number 26370 of 2021 has been in the fourth line of the said order instead of WP
1762 of 2022. 1762 762 of 2022.
22. First off, insert view of the matter, considering the nature of a rectification which is required to be met, this review application is disposed of with an observation that WPC number so and so shall be read in the order dated 15/2/2023 in place of WPC numbers 26370 of 2021. First off, the present order shall be read along with the order dated 15/2/2023 passed in WA number 1054 of 2022. Application stands as follows.
Yes. Item number 7.
State has to file a counter. And we have also judgment.
It has to file counter, then we are just adjourning it. Discuss matter on 2 weeks. See, why are you making a mention?
See, matter is pertaining to the elephant movement. In Tangi range, around 40 elephants they create in Habo Clutch.
You can make a mention on Monday. Make a mention on Monday.
Last date of submission of tender tomorrow.
Huh?
Last date of submission of tender tomorrow, my lord. I had already filed a memo that was not done.
It must have been done something.
But I had already filed that memo.
When?
Already filed a memo on 9th. That was not allowed.
Today is not allowed.
No.
Then what can be done? Give
Last date of submission tomorrow.
We will see.
My
Since my lord did not hold the court on 9th, may I pray, I am not inclined to file any counter, so far limitation is concerned. But my lords were pleased to direct me, my client to pay 10,000. I filed one modification. May I pray before your lordship?
Mr. Kaur, if I remember correctly, you have been allowed to file a counter subject to payment. So if you don't file, no question of payment.
Yes, my lordship.
Yes, that is the thing. Don't file counter. Don't.
So all you have to do,
I'm not inclined to file it.
so you just have to give a memo or some affidavit saying I don't want to file counter. No problem.
There is no problem.
I want to mention that this is regarding a writ appeal. This is regarding the writ appeal that has been decided by your lordship. IA has been filed.
What that lady, the term deposit, that case?
Yes.
Yes. So now what IA? Dispose of
It's
appeal.
not yet released in her favor. So that when lordship has passed the order, let it be filed. Tomorrow, my lord.
Give it to you.
I don't make a mention. This matter was specifically listed for today. It is not listed today.
It was directed to be listed today. What is the matter about?
Matter is they were extending of the stone quarry.
Extending a stone
Not
query.
that are there. It can be taken up next week. Make a mention next week. All right.
They have the proceedings going to finalize by 17th. What has happened? The opposite party has invited a national open tender for procurement certain goods which are.
You can challenge that. It is not that urgent that it should be taken up. See, if someone is.
Finalized, it's a goods under the MSME development and they should go for a limited tender. They're going for a national tender. Going to finalize by 17th.
Give your civils.
And it's second content, whatever. Yes, second content.
Second contempt.
Second content.
Want taken up today? An urgency you want it taken up today?
Why don't you make a mention on Monday? See, make a mention of only such cases where the urgency is such that it should be taken up today or tomorrow. Otherwise, make a mention on Monday.
For delivery of order, item number 1, WA 1737 of 2022.
Yes, we have dismissed. You can file a review. Review file कर सकते हैं आप.
सेम कोर्ट में रिव्यू फाइल कर सकते हो. यस सर.
For judgment item number 2, WA 30284 of 2011.
We are not inclined to entertain this petition filed more than 3 years after the petitioner's arrest for award of compensation. Petition is dismissed. I have attempted to dispose of the cases in which the judgments were reserved. We are still trying. We
I have
may have to release few of them.
Item number 3, WPC 24658 of 2013.
This application is dismissed.
Item number 4, WPC 28287 of 2013.
This application has been disposed of with certain observations.
Item number 5, CRL REV 503 of 2221, batch of matters.
In the absence of any specific bar under the NDPS Act and in view of Section 51 of the NDPS Act, the court can use the general power under Section 451 and 457 of the CRPC for return of seized vehicle pending final decision in the criminal case. The trial court has the discretion to release the seized vehicle in the interim, but the power has to be exercised in accordance with law in the facts and circumstances in each case. In view of the above, the cases may be listed before the assigned bench for disposal in accordance with law.
I agree.
Item number 6, WPC 35926 of 2022.
Dismissed. Yes. Your case has been dismissed mainly on the ground that we cannot determine the amount of compensation. And you were relying on my decision, which I still doubt correctness of that, whether I was correct in awarding particular compensation.
Item number 7, WA 2072 of 2023.
The judgment dated 15/11/2022 passed by the learned single judge WPC OSC number 1359 of 2019 is set aside. The writ appeal is allowed. There shall be no order as to cause.
I agree.
Item number 8, WPC 8905 of 2024.
The writ application is dismissed. You knew the result, Mr. Talib.
Item number 9, WPC 10185 of 2024.
We reject the challenge to the virus of Rule 4.1 and Rule 4.2 of the Orissa Engineering Service Recruitment and Conditions of Service Amendment Rules 2023, amending Rule 7.3 and 7.4 of the Orissa Engineering Service Recruitment and Conditions of Service Rules 2012 and uphold the same. As regards advertisement number 19 of 2023-24 dated 28/12/2023, we find no merit in the submission of some of the counsel for the petitioners that the impugned advertisement should be quashed on the same ground as advertisement number 20 of 2022-23 dated 18/3/2023 had been quashed in the earlier batch of writ petitions, as a level playing field has not been on the ground that the level playing field has not been provided to the candidates who have not appeared in GAT for 3 years, as there is no stipulation that the highest valid GAT score for the last 3 years will be considered. After having held thus, in view of the facts and circumstances discussed above, we deem it just and equitable to direct last date 12/1/2024 indicated in advertisement number so and so dated 28/12/2023 published by the OPSC for submissions of examination of applications shall be further extended by a suitable date so as to give an opportunity to the candidates who were otherwise eligible on account of the age and educational qualification as on the last date of applications as fixed by the state government of the OPSC to appear in the GAT examination at least once and submit the applications along with the valid GAT score, if any. Full stop. The applications of candidates who had earlier appeared in the GAT examination on the last date fixed by the state government /OPSC. The applicants who were eligible as per the terms of the advertisement and had applied pursuant to such advertisement and whose applications have been processed in compliance of the interim order dated 17/3/2024 passed in WPC number 42059 of 2023 and batch need not apply again. All the writ applications are allowed to the extent indicated above. We agree with the view expressed by the learned single judge in the interim order dated 17/3/2024 passed in number 948 of 2024 and back that the candidate should have been given one chance to appear in the GAT examination. The writ appeal is accordingly disposed of, confirming the order of the learned single judge in WPC number 586 of 2024 and batch passed on 17/3/2024 to the extent indicated above. It goes without saying that the observations, direction of the Supreme Court while disposing of SLP diary number so-and-so should be kept in mind, and the applications of candidates who had applied earlier in response to the previous advertisement should not be rejected on the ground that they had become overaged when advertisement number 19 of 2023-23 was published. There shall be no order as to cause.
So we have upheld the statutory provision. We have upheld the advertisement also. We have the thing, those who had applied, their cases shall be considered, but the date has to be extended, the last date. But because of extension of last date, those who were not otherwise eligible, except for that gate, I agree.
Item number 10, WPC 13788 of 2024.
Challenging the self-same order dated 15/12/2023, the petitioner had earlier filed WPC number 35166 of 2023, which had been dismissed by this court on 21/11/2023, and special leave petition civil diary number so-and-so filed against the order of this court had been dismissed by the Supreme Court on 19/4/2024. In our view, the petitioner now wants us to sit as an appellate court over the decision of another bench, which is impermissible in law and would also amount to judicial indiscipline. Beyond the above observations, we are not inclined to entertain this writ application and dismiss the same.
Agree. Yeah.
To be mentioned, item number 11.
How can you take out those factors? Because they are going to delay for a daughter of marriage.
Who?
For respondent and how can you take out 2 weeks after?
No, what for the matter was directed to be listed. Just a minute. All it has requested on behalf of the respondent. You're for the respondent.
Yes.
List this matter on 2 weeks.
2 weeks after.
2 weeks. What? I call up. Hey, David. State the call.
Item
Adam, so difficult. Sorry.
Actually, on the last occasion, a chance was given to the learned counsel appealing on behalf of the OPC and the state government.
Counter affidavit is ready. We have to file it today.
File it.
So on the last occasion, it was said that it is going to be filed.
Yes,
in
yes.
due course of the day.
Very busy, you know.
Randeji states that counter affidavit is going to be filed in course of the day. Which is this matter?
item 12.
Is that appointment, right?
Yes.
Person below the merit list have been appointed.
This matter on. Have you served a copy? Will you serve?
Yes, today I will serve copy.
A copy of which shall be served upon learned counsel for the petitioner today itself. Of listed matter on
Has OPSC filed a counter?
2 weeks.
Learned counsel appealing on the OPC have also not filed.
OPSC, who is the pay?
Mr. Pradeep Kishore Pandey, learned senior advocate.
All right. That's the case on 2 weeks. So stop in the meanwhile. It will be open for the OPSC to file counter affidavit. So stop. The petitioner shall be at liberty to consider the counter affidavit filed on going to be filed on behalf of the estate, and file rejoinder of if any in the meanwhile. Yes.
Mentioned.
Orders were.
You will take up once one restoration matter is there. If
Item 13.
The repetition has been dismissed by your lordship on dated 29/8/2024, non-appearance of the petition
29/8/2024. And when did you file your restoration?
27/9/2024. We did that.
27/9. Oh, that is time.
What is this?
WPC 20159 of 2012 is to dismiss for default by an order dated 29/8/2024 in the absence of any representation on behalf of the petitioner. This application has been filed for. This application came to be filed on 27/9/2024 for restoration of the said petition. Also, considering the facts asserted in the present application, the same is allowed. Let WPC number 20159 of 2024 be restored to its original place.
What happened to WPC 23387 of 2010?
That is also dismissed.
Dismissed. Not yet restored. Or dismissed on merit.
Dismissed on one prosecution.
restoration.
There are two methods.
The other one is not listed. You filed restoration.
Obliged.
Yes. So, any very urgent matter?
Let's see in item number 18. The statement, find the expert committee report. But they have taken 6 months time. 2 experts have been engaged by the state government clerkship. They have to file that report. That we need. That will can be in item number 18. Let's see.
We admire which you have conducted this case, but let it come on Monday.
Let's see, please.
What is it, that elephant car thing?
No, let's see. It is pertaining to Silka police.
Okay.
Item
We received instructions. They have,
Monday on Monday. Let me check. One week.
internal communication.
This that why don't give that. That is, yes, you are right. That's internal communication. Why
Should we file an affidavit to that?
file an affidavit? We are just adjourning it for 2 weeks.
Let's see Monday or let's see.
Monday.
Let's see 22nd.
It will come on 22nd.
Let's see.
Any?
House's kind permission, item number 19, if you Lordship kindly permit. Item number 19, my lord. This is a batch of expeditions. It is with regard to that 9 judgments. We are traders, my lord.
What do you want?
They, well, it is for listing only because it has been pending since long. There,
Pending since when?
2009. 2018, yes, 2018. It has been pending and our money has been stock up before the respondent OMC.
There is an order in this matter by a previous division bench that we are awaiting the disposal of the Udaipur Chamber of Commerce matter, which is pending in the Supreme Court. And that is listed on the 31st of January.
All right, it will be taken up later.
So we can list after 31st.
31st has to be, because that has to be decided first, then only.
Can we?
So far as my matter, so far as my, so far as my matter is concerned, my lord, I have moved an application for detag of my matter because I'm not falling under that category. My lord,
Second week of February.
Grateful.
What is mentioned, my lord? Item 12, my lord, I am the OPSC. 6 weeks more than.
In absence, we have granted time.
Yes, Mr. Mohanty.
That item number 13, that infrastructure matter. That your nursing can dispose of it, telling them that within 1 month they will do all necessary things, that would suffice. Let it come to an end.
Last but your lordship observed that according to the para of my counter, your lordship will dispose of the matter. Your lordship may pass on directing the authorities to expedite the.
All right, tomorrow we'll do it.
Yes, ma'am.
Tomorrow we'll see it. Yes. Something has been done.
Yes,
No, nothing has been done.
No,
the SIA, that the state in the Environment Impact Assessment Authority is to grant the environment clearance. And that is awaited, my lord. Otherwise, we have sanctioned mining plan, everything.
Give them a time frame so that it will be done.
Yes.
Otherwise, it will take years.
Lordship may fix up 15 days for
How much time do they take generally?
They can.
They are not state agencies that I am not.
Mr. Panda, if I remember correctly, last date we had asked you to inform CR.
Yes, I had
we will be
informed.
taking up the matter.
Communications I have made. No response is coming
Very
from there.
Mr. Panda, the difference between other cases and this case is
Because they are not state agencies, my lord.
no, may not be a state agency, but because of
Consist of all state
because of the
Exhaustively, I have
absence of the part of the state.
kindly have a glance, my lord, my communication. I have so emphatically stated that these are public interest
Mr.
matters.
Panda, again, important thing is your communication, whether it has been dispatched.
Dispatched, not dispatched, then I have personally also communicated to them. There were 2 letters, not one.
Personally communicated.
From my own mail also, I have communicated that you have not responded, you should have responded. It's urgent matter, matter is fixed to 15.
But sometimes we make observations that may go against the state also. Just avoid that. There has been failure on the part of the state agency also in this case.
No, in this case, we have expedited our process, we have sanctioned the mining plan very quickly.
That's easy to be blamed. Then whether the contractor is to be blamed. What wrong he has committed?
No.
And
we are saying that. That is why we are saying that. No, I'm expediting the process. And your lordship's direction will not be effective.
We will do.
Yes.
Pass orders tomorrow.
Tomorrow.
We were under the impression that in the meanwhile, the entire exercise shall be completed.
I will again remind them tomorrow. Today.
File
For tomorrow.
the communications along with the memo which you have communicated.
Yes.
And tell them that we may pass certain orders tomorrow.
Yes.
So they may avoid it if your SE, what is that?
State Environment Impact Assessment Authority.
That
Yes.
consists of all the state agencies.
So if they can decide it today, it's all right. If they don't decide it, then
Tell us what they are going to do. Instead of ignoring the vote.
Again, today I will make a communication and
since when the matter is pending before
Yes. That I will do below.
What yes? We are asking since when is the matter pending with them?
No, since last 10 days, 10 to 2, I have to calculate.
all right. We'll see tomorrow. The reminders.
Yes.
Lord, just one indulgence. Lord, in item 19, your lordship would be pleased to extend the interim order.
19.
The interim order. I'm deeply.
Past earlier.